met Phoebe Jonchuck?
Yes.
When the defendant came by with Phoebe Jonchuck, did he go upstairs to speak with Ms. Torres?
Yes.
Did he take Phoebe with him?
Yes.
Was Phoebe up there the entire time for that conversation?
No.
Did Phoebe come back downstairs?
Yes.
Tell me how that occurred that you saw.
Typically, since it's family law matters, I always ask for children to try to stay with me downstairs so that way they don't hear about their other parent. Initially, I asked if Phoebe could stay down with me while he met with Ms. Torres, and he said no. So she initially went upstairs, and then shortly after, maybe 5-10 minutes, Genevieve called me to come upstairs and to take Phoebe downstairs. So I brought her downstairs, and she sat with me, and she drew pictures, my name, and spent some time with me.
So you had crayons and pencils and paper for such situations?
Yes. Keep the kids busy.
How long was the defendant upstairs with Ms. Torres before he came down?
He was probably in our office maybe 30 minutes.
When he came downstairs, did he leave the office?
Yes.
Tell us how that occurred.
So he came down the stairs. Genevieve came halfway. He said it's time to go, and let's go, let's go. And Phoebe didn't move. She just froze and just looked at me. And so he, bent down and grabbed all the crayons and the papers and shuffled everything and just threw it in the bin. And she just stood there, just staring at me. Didn't say anything, didn't move. So he grabbed her by her arm, like to yank her, let's go. And he immediately, rushed out the door. It was very rushed.
Did he later make phone calls to your office?
Yes, he did.
How many phone calls did he make?
7 total.
Objection. Judge McBride? Yes. Jonchuck,
We would be willing to waive his presence so he can get back and get
It's
some
fine.
rest.
Okay, that's what you want, Mr. Jonchuck?
Yes, Your Honor.
Okay, no problem.
You want me to pursue no bailiffs in court, Judge?
Yep, I think we're all safe.
When did you receive the first call, do you recall?
At 1:11 p.m.
And what was that call?
He started to tell me that he's related to the Pope.
I'm sorry, you said what?
Am I to talk about what it was about?
Yes.
Okay. He called me saying, "Hey, Kirsten, I'm related to the Pope."
This is January 7th, ma'am.
January 7th.
Related to the Pope.
Yes, he's related to the Pope, and he's in their ancestry bloodline. And he was very excited. And he told me he was still at St. Paul's Catholic Church. And that was, the substance of the first two phone calls was just about him being related, to religious.
How long were each of those first two phone calls?
A couple minutes. The first call was at 1:11. He talked for 30 seconds, hung up, called right back. The second call was at 1:11 again. And that's when he just proceeded about being related to the Pope.
Did he call again?
Yes.
When?
20 minutes later, around 1:30,
What was that call about?
that's when he proceeded to say that he didn't believe Phoebe was his daughter. He believed that Michelle had an affair with his father and that Phoebe was not his child.
How long was that call?
Each call was maybe a couple minutes.
Was that the content of that call?
Yes,
What was
along
it?
the lines of her not being his, and could we possibly get a DNA test? And I'm like, absolutely, of course we can do that, no problem.
Did he make another call to you?
Yes.
How long after that third call?
He started calling again an hour later, around 2:30.
Yeah, and what was the content of that call?
He was very down at that point. He was, explaining that he didn't know what to do anymore. He wanted to protect her from this craziness. I don't know what I would do without her. If I can't have her, then no one else will. And I just responded, no one's taking her from you. Everything's okay. Relax. We can get this handled. And just trying to talk him down at that point.
Do you recall what the office number was?
813-443-2132.
Okay. Were there any calls after he said, if I can't have her, no one else will or can?
Yes. There were 7 calls total. So then he called again maybe 10 minutes later. He proceeded to ask if we can do a DNA test. Can I call DCF? Of course I can call DCF. No problem. I think I need a DNA test. I need a DNA test.
He asked you if he could call DCF?
He asked if I would call DCF.
Okay.
Yep. He said, could you call DCF? He was the one that brought DCF up initially. And he just, kept urging that he wasn't sure. He didn't know what to do. I don't know what to do. Can you get a DNA test? He just kind of repeated himself.
How long was that call?
There were very short calls. He would talk for, a couple minutes, hang up, and then call again. So it was 7 calls in the course of an hour and 20 minutes, I believe.
Have we gone through all the calls?
No, there's one more last
One more call. What was that call?
The last call, I was upstairs with Genevieve, speaking with DCF at that point, when he called in the last time. So I ran downstairs, I answered the phone, and that's when he's just, hey Kirsten, I just want to let you know, we don't need a DNA test, everything's okay. Phoebe is mine, and everything's gonna be okay soon. Everything's gonna be okay tomorrow. I'm like, okay, great. You know, I'm glad everything's okay. And it was kind of a quick call, and then I didn't hear from him after that. The call stopped, and I left the office at that point.
Have you told the defense attorneys in this case this conversations you had with Mr. Jonchuck?
I had a 45-minute phone call with them a week or two ago.
With
Like
them?
47
who
minutes.
I'm sorry. Was there one you talked to, or was it on speakerphone?
It was speakerphone.
Who was present?
I think it's attorney Greg Williams asked if it was okay that he could put me on speakerphone. I said absolutely, and he named off probably 5 people.
Who did he name off?
There were a couple attorneys' names, and I believe there was an
Jessica Manuel?
I don't recall the name specifically. I know that it was a few of the attorneys on that side, and I believe there was an expert on the line as well.
Do you know who that expert was?
I don't recall the names. I didn't take a note or anything. They introduced themselves, said hello, and then they started asking me questions. I talked about each call. They had me repeat my statements a couple times about my times and, you know, things that I remembered, asked me questions. Before I got off the phone, Greg asked the attorneys, was there any other questions that they had before I got off the phone? Everyone said no, they were good. And then that call ended.
So everything you spoke about here in court, did you tell them?
I had the same conversation, yes.
Is there anything that you did not tell them about the phone calls?
No, not to my knowledge.
And this was about 3 weeks ago?
It probably had been 2 weeks ago or less. I mean, it was very recently. In the past 2 weeks, I spoke with them. And I had been on subpoena for a very long time from them.
You said it was a 45-minute phone call?
Yeah, I think it was like 47 minutes. It was a long time because I was at work, so.
Nothing further, Jim.
Do you have any questions of this witness for the prosecutor?
Good afternoon.
Good afternoon.
Let me ask you a question first.
Sure.
I wasn't up here, but I think I understand that you talked to the prosecutors just recently?
Yes.
Okay. Did you talk to him back at the very beginning of this case?
Both sides called me initially, but at the time there was attorney-client privilege issues, so I never discussed substance of the phone calls or any conversations between me and Jonchuck.
Okay. And the prosecutor never brought you into their office or anything?
No. I spoke with them last week for the first time since then. Because I had contacted offices because I didn't know. I've been on subpoena for years now, and I wasn't sure if I was going to be testifying or not. So I reached out, and I spoke with them on Monday in regards to today.
Monday, a few days ago?
Yes.
And I'm not sure I understand that. They called you or you called them?
I called both offices to inquire as to whether or not I should plan for my schedule because I work.
Okay.
So I had asked if I was going to be needed or not. So I had an expectation for myself.
Okay. And You said that, well, I think with the way this happened, you and Ms. Torres called 911 after Mr. Jonchuck left?
Yes, as soon as he left, we, she was she broke down and was extremely concerned at that point. So we said, let's call 911. So I dialed 911, and then I transferred it over to Genevieve.
Okay. And then where did you go? Did you guys close the office and leave, or what happened?
So at first, we called 911. As soon as he left, I ran outside to grab his license plate because I knew something was wrong. So my first instinct was, let me run outside real quick before they come out the parking lot. So I grabbed his license plate, came back in, and that is when Genevieve had explained the situation of upstairs, their conversation upstairs. So we proceeded to call 911. They went out to St. Paul's Catholic Church, which is where we said he was going to be. And then a cop called us back to say, hey, this doesn't meet the criteria to have him Baker acted. We're letting him go. And, at that point it was, please do something, sorry, there's something we can do. So we were immediately nervous.
Who said please do something?
Attorney Torres kept urging. I'm sorry, I was right next to her.
Right.
But Attorney Torres was urging to, 911, to the cop at that time, please do something. They said that they were releasing them. So we were thinking, we need to get out of this office. He knows that we are clearly the ones that called the cops on him. So let's go. Just nervous. So we took a long hour and a half lunch. And then we came back to the office.
Okay.
And then once I came back to the office, he started calling around 111 was the first phone call. And we didn't call DCF till around 2:30.
Okay, and I heard you say that there were 7 phone calls, and I only caught 6. I missed one somewhere.
There were 7. There was 2 that were on the same minute. I believe it was the 111. He called twice. He talked for 30 seconds, hung up, called again. Okay. And then I believe the 232 phone call, there was 2 as well. He hung up and called right back. So I just kept taking his calls because I wanted, to try to get the information that I could.
And how did you figure out what times he called?
Because we have caller ID.
And, so were you taking notes when you were talking?
I work for an attorney, so I know. Take notes as much as you can. Always, try to be, as detailed. God forbid anything were to happen. So I took, as soon as we got back from, after the DCF call, I decided to start writing down my notes before I left the office because just something didn't feel right. So I went to my phone and I went back and I saw his phone number and I just wrote down each number and I just tried to, do a quick jot down of just what I remembered for each call, just a very brief note.
And then what did you do with those notes?
I saved them for 4 years.
Okay. Do you still have them or you don't?
I do.
And did you give them to anyone or do you just
No, I
kept them
didn't.
in your possession?
Yeah, no one asked for them. Like I said, I hadn't been contacted by either side until 2 weeks ago. So no one requested a copy of them. I think prior, there was, like I said, there was attorney-client privilege issues, being that I'm an extension of Attorney Torres, so we wouldn't release those when a subpoena was sent to our office requesting a copy of the file.
When Mr. Jonchuck came in the office, and when he was upstairs talking to Ms. Torres, could you hear anything?
No, I mean, you could hear voices, because, the walls are thin, but I couldn't hear actual words of what they were discussing.
Okay.
The door was closed.
And did you hear anything in the time that he was in the same area as you? Whether it be the same room or the stairway or anything else?
What day are you referring to?
On the 7th.
No, just the let's go, when he was trying to leave with Phoebe.
Oh, how about let's go all the way back to when he came in. Did you hear him say anything?
Well, I mean, I greeted him when he first walked in. I'm the first person you see. So he came in with his daughter. I said hello, and I love children, so I was, said hello to her, and that's when I asked if she was going to stay down with me, and he said no, and they went upstairs.
Okay.
It was pretty quick. He was very rushed.
So he said nothing that caused you any concern when he came in?
No.
Okay. And then the phone calls that you've described, you have notes of those, and that's how you're able to tell us what was said during those phone calls?
I have those brief notes, but there's certain things that you'll just not forget. I mean, it's something that stuck with me since that day.
Do you remember him hurrying to leave because they had to get to St. Paul's?
At the time, I didn't know that he had an appointment at St. Paul's Catholic Church, but I could just tell he was rushing. I didn't know that he had to be somewhere at a specific time at that point. As soon as I came in that day, I came in a little bit late, and Genevieve had let me know that Mr. Jonchuck was going to be stopping by shortly.
Okay. Did you hear him say that the angels were coming down?
No.
Did Ms. Torres ever tell you that she heard that?
It was my understanding that he was going to St. Paul's Catholic Church because the angels were coming down. But that conversation was with him and her upstairs.
Okay. Did you ever hear him say that when he was in the office at any time on the 7th, did you ever hear him say that he thought Phoebe was possessed?
No. He didn't say that to me.
And did you ever learn that he had said that to Genevieve?
Yes.
So I want to make sure I'm clear, so that the information that you got from Mr. Jonchuck relating to these statements that were made, they were all made in the context of phone calls that you answered?
Yeah, so I'm always the one that would answer the phone. So anytime Mr. Jonchuck called, he spoke with me.
Okay.
So he called and specifically, saying my name, Kirsten, XYZ. And they're all phone calls, verbal.
All right. And none of that information came through personal statements to you while you were in the office on the 7th? Outside of the phone calls, when he came in and then when he left, you didn't hear him say anything that was out of the ordinary or strange that you thought?
No, it was just the phone calls.
Right. So I think where I messed up on the phone calls is we have 2 times where we have 2 phone calls with the same time.
Correct.
Got it. And so the first 2 are at like 1:11?
Mm-hmm.
And then what numbers correspond to what other 2 numbers like doubled up?
I believe it was the 232.
232, and that's 4 and 5?
It was, if I remember correctly, it was 111. He called again around 1:30, and then he called, I believe, twice at 2:32, again at like 2:37, and then the last one was 2:45-ish, and that was the last contact that I had with him directly. I left the office, and that was it.
Okay. Ms. Malcolm, I just kind of want to ask this question. Sorry I don't know any delicate way to answer it, but
That's fine.
You have some experience with mental illness? Not
Yes.
mass. In other words, you're in your life experience. In your life experiences, have you come in contact with
Yeah, this
mental
is getting
illness?
outside the discovery
What's the
violation.
relevance of that?
Because I think that she's going to be able to tell us that she has opinions about the way his voice changed, his attitude changed during the phone calls, and that she has specific experience with what, or she believes that sometimes he sounded depressed and sometimes he sounded.
Are you gonna ask those questions?
I had not planned on asking this question, Judge, and I think that also goes to show that they are not surprised by any of this.
Well, I understand, but you're not planning to ask her those questions anyway, correct?
No, no, ma'am.
Okay, so you would be the one asking her, so we don't have to delve into that.
Okay. I don't have anything else, Judge.
Anything further from the state?
Nothing for the judge.
Ms. Malcolm, I have a couple questions, just so I get this timeline straight.
Sure.
Okay? So a couple weeks ago, the defense called you. You
Yes.
called them.
They met with Attorney Torres, and then I believe at that point is when they wanted to speak with me.
But you spoke with them on the phone.
Yes,
Okay.
I was at work. Genevieve let me know that they would be calling me.
They would be calling. Okay. So they call you at work,
Mhm.
and you have this conversation where you go through the 7 phone calls.
Yes,
And that was a couple of weeks ago.
yes, maybe 2 weeks ago.
And you had not talked to the state since this case began, and you were told you had to claim attorney-client privilege.
Yeah,
Is that correct?
the first week I spoke with a female attorney, I don't remember the name. At that point, she contacted the office and let us know that she would be Jonchuck's attorney. And at that point, I couldn't talk to anyone. I didn't know what I could or couldn't say,
Okay.
and no other communication until literally 2 weeks ago.
But you never talked to the state since it very first happened, and you said, sorry, attorney-client privilege, until last Monday, this Monday of this week?
Oh, no. Are you
Okay.
talking about the defense or?
The state attorney, the
Oh.
gentleman over there, or
Yes.
their counsel.
I spoke with their office late last week, and that's when we arranged the meeting to
Okay.
speak on Monday. This Monday.
But that was the first time since 4 years ago.
Yes, yes.
Okay, and then, who did you ask about whether you needed to honor your subpoena?
Well, I had spoken with their office the defense office a couple times, as we didn't know, whether or not I was going to be needed. So they kept telling me that I was on hold and that they would contact me and let me know.
Okay,
After I spoke with them 2 weeks ago, I didn't hear anything else from them, so I assumed they weren't calling me anymore,
okay.
based on my statements
And
maybe.
so when you called the state attorneys Monday, why did you call them?
Because I wasn't sure how that, I reached out because I wasn't sure if I was being called by either side. If I had a subpoena from one, does that mean that they have to send me a separate subpoena, or should I just expect to clear my calendar? I work for a busy attorney, so I was just trying to figure out what my expectations were going to be these coming weeks.
And did you have a conversation with them at that time about these 7 phone calls?
We didn't discuss anything specifically until Monday. Yeah.
Well, how did you come to have that conversation? You already knew you were supposed to come, right?
By the subpoena?
Yes.
Yes.
Okay, so the conversation wasn't Monday where you were trying to determine whether you had to honor their subpoena. It was before that.
I didn't have a subpoena from the state. I had a subpoena, I believe, from,
Okay.
I believe it was the defense. I thought it was them.
Okay.
I'm sorry.
But the conversation you had with the state, just to make sure you didn't have to be here.
Yes.
When was that?
I spoke with them on Monday.
Okay. And then, who did you talk to? Do you know?
I contacted attorney Doug Ellis,
Okay.
his office, and
and
then
then-
he contacted me back.
Did you talk about anything except, yes, you need to come?
He said, let's get together and discuss. If you're being called, it would probably be Wednesday or Wednesday of next week. But, you know, let's talk further. Let's schedule a time to discuss everything.
Okay, and then when did you discuss everything?
On Monday.
Here or on the phone?
This Monday, I have a baby. I asked them to come to me.
So they came to your house,
Yes.
both of them?
Yes.
And you just told them the same thing you told the defense?
Correct.
A week or so prior?
Yep.
Okay, anybody have any follow-up questions?
No, Your Honor.
No?
No, Judge.
Okay, anybody want to argue anything about the Richardson hearing? I don't need any argument, but I'll listen.
Is the court determining that there's not a discovery violation?
I'm about ready to, so if you want
Okay.
to tell me why I shouldn't.
So under 3.220, the state has an ongoing discovery obligation to provide to us any recorded statements or oral statements of the defendant. That is regardless of whether they intend to offer it in rebuttal, regardless of whether they intend to offer it only through impeachment, regardless if the witness is listed, regardless if the defense attorney contacts that witness on their own and obtains those statements. The rules of evidence are what put us on notice of what evidence will be introduced in the trial. Not me personally, I came in the very tail end of the conversation, so I didn't personally speak with Ms. Malcolm, but when people from our office spoke with Ms. Malcolm, we were of the belief, obviously, that because we had not been provided any statements, this was not going to be introduced. We purposely did not have Dr. Macklis get into it. These statements were never disclosed to Dr. Mayer. These statements were never disclosed to Dr. Otto. It sounds like as of last week, the state was on notice that she wanted to come in. There was a discussion last week that attorney-client privilege has been waived. They met with her on Monday. On Monday, Dr. Macklis was still on the stand. We could have cured the issue at that point. We could have provided the information to Dr. Otto. We could have provided the information to Dr. Mayer. The state instead sat on these statements that are the defendant's statements that was intentional. They have not, still have not provided any content of them. We have obviously the statements from Ms. Malcolm today. But at this time, we have rested our case. All of our experts have gone. It would be improper and highly prejudicial. We have conducted our case under with the understanding that the rules of evidence would be followed and that the only statements they intended to introduce had been disclosed to us. And so we can't go back now. And so at this point, there is no way to cure it. The rules of discovery are very clear. It does not matter if we took her deposition and weren't aware of the statements. It does not matter if we spoke to her and obtained the statements ourselves. It does not matter if they were only going to be used in rebuttal. As soon as they became aware of an oral statement of the defendant, they have an obligation to turn that over to us. And it sounds like they became aware of some statements at the end of last week. And yes, no. The testimony is that she called out last week to talk to them. They said, let's get more detail. Let's meet on Monday. And so on Monday, for sure, as of Monday, they had the statements. We hadn't put on Dr. Otto, we hadn't put on Dr. Mayer, and Dr. Macklis would have still been on the stand. And so because of that violation, we are prejudiced now. There is no way to fix it. It sounds like they're trying to introduce the statement to somehow show that he acted in conformity with that statement. And so there's a whole bunch of other issues tied to that, but it's apparently willful because we've been in court with them every single day since they spoke to her. We have spent numerous hours together. It is certainly not trivial. It is substantial. There's a number of phone calls, including one indicating if I can't have her, no one will. And it certainly resulted in prejudice and harm at this point because they waited until the defense had rested their case before letting us know that these statements were going to be introduced.
Give me 1 second, I just want to read it. Do you have this case?
And I provided the court Ibera
Yes.
State, I-B-A-R-R-A.
Just let me read it.
I was just trying to put the site on the record, Judge. I
Okay.
won't speak about it. Is it okay to put the site on?
Yeah.
56 Southern 3rd 70, second DCA case from 2011.
Did you ever get subpoenaed by the state?
I only got one subpoena. I thought it was from the defense.
Okay.
It wasn't.
It wasn't?
No. The state
Okay.
sent out all the subpoenas except for the couple we sent to our experts, so all the subpoenas would have come from the state.
Okay, so we can all agree it was
sorry.
your subpoena?
Yes.
Okay.
I'm sorry.
That's okay. You're not expecting it. No,
I
that's-
didn't read it good enough, I guess.
When you had the discussion when Mr. Baldwin and Mr. Ellis came to your house on Monday,
Mhm.
did you tell them that you would talk to the defense?
Yes.
Did you tell them what you told them?
I told them both exactly the same thing. I mean,
Okay. Any follow-up question?
No, Judge.
Okay. Do you want me to just rule, or do you want to say something?
Without knowing what you're gonna rule is kind of hard for me.
Well, say something. I mean, there were some points brought out, so give me your argument.
We did not have a formal waiver of attorney-client privilege until the start of the trial. I mean, I believe that was when Ms. Torres was getting ready to testify. I think it was in trial. We were contacted by the witness. She told us that she had spoken, and all this information was provided to the defense, and apparently the defense expert as well. We indicated to them that we were going to call this witness. I believe that was yesterday that we were going to call this witness. So that was not a surprise that we were going to call this witness. They have been informed of this witness.
Yesterday you told them that?
Yes.
And still did not give us the statements.
I know, but was there any conversation about why you were going to call this witness?
We just said we were going to call a couple witnesses and today, and she was one of them we were going to
Okay.
call. And then exclusion of the testimony would be the most severe sanction. It shouldn't be. It's not a surprise to the defense. That's what Richardson is to prevent surprises. This is not a surprise to the defense. They will have a rebuttal, which they can bring in their experts, all of them, one of them, whatever, to deal with that statement if they wish to do so. But they made a decision to know that evidence and not do anything with it. And the state discovered it in the middle of the trial because we were prevented from discovering it prior to that. So we believe that there's been insufficient prejudice shown, and we ask the court to allow the statement.
I mean, I suspect that their argument is going to be, and they can make it, that it was a strategic decision on your part, which probably is okay, not to tell them, so they would be surprised after they put all their experts on. What do you say to that? You don't have to respond at all, but I think that's where, is that where this is going?
It certainly seems that way.
Well, is that what you're gonna argue?
I'm gonna argue that there's no way we can fix this prejudice now. We have already.
So
put
it's
on
a
all of our
procedural
experts.
prejudice because to fix it, you would have to call back all of your witnesses.
Well, and they would lose credibility then. It would look that in some way we didn't turn over some information to them. If we were put on notice that it was going to be considered by the state, introduced, provided to the state's experts, we would have obviously done that.
Well, I think you can fix that. I can think of ways to fix that. So, it wouldn't make sense for Mr. Ellis to know that you were privy to the same statements he was and give you an oral summary of them. That would be kind of ridiculous. I guess I could make a finding, oh, you didn't give them an oral summary of the statements that you already had.
Well, obviously I have no reason to believe that the witness is not being truthful, but for the state, that does not satisfy their discovery obligation. They are required to give us those oral statements. What if she had in fact told us something different?
She didn't.
Well, there are a couple differences, but that's neither here nor there. The issue is if the state had followed the rule and provided us this oral statement, we perhaps would have taken her deposition to get that under oath. We would have certainly provided the information to our experts in considering their opinion.
But there's no evidence they knew about it.
No, they had evidence that they knew about her. They've listed her. She's been listed for witness since January of 2015. And then the attorney-client privilege was
Right.
waived in September of 2018. If they had any concern or confusion over that, they absolutely could have brought a motion before the court, Judge. That never happened. They didn't come in and start saying that we thought this, once we turned over the entire attorney-client file that we were provided, which did not contain the notes of the phone calls, so we turned that over to the state. For them to now say, well, we were relying on some attorney-client privilege, that's disingenuous. If they really thought that, they should have come before the court when we've given the attorney file.
Well, the very attorney who we're talking about required a waiver from Mr. Jonchuck before she testified.
And that it was never brought before the court. And so that's what I'm saying. If they believed that there are remedies, there are available means for them to address that with the court. In fact, when they actually asked us and said, well, we think attorney-client was waived when you gave us the file, I said, yeah, I agree it was. So, but when they even first asked us, we told them it was waived then. So we have proceeded on our
But she
case.
didn't think it was waived. What difference does it make?
What Ms. Torres believes has nothing to do with the discovery obligations of the state attorney's office.
I think they didn't have the statements.
They had the
And they
statements
couldn't get them because the lawyer was claiming attorney-client privilege.
on Monday, when we were still in our case, they had those statements. We
So,
were in court
I
with them
understand.
Monday. We were in court with them Tuesday. We were in court with them Wednesday.
Okay,
Never did they tell us these statements.
so I don't know. It's not intentional. I'm not gonna find that it's intentional. That they intentionally didn't disclose these statements because they received them after you all received them. I guess there's a technical discovery violation and that Mr. Ellis or Mr. Boland should have written you a summary out of the statements that you already knew about. I would agree. Where does the case say, you were talking about that they have to provide you statements if they're gonna use them in trial that you already know about? Where's that? Because this case talks about the failure to have the hearing.
I'm trying to find the one that specifically references the depots. There's case law for that, Judge, also. It's 3.220.
Well, I need to see that.
B.
Where it says that even if everybody knew what the statements were, that it's a discovery violation if the state doesn't provide that.
It's a discovery violation if they don't follow the rule. Once there's a discovery violation, then the court, in conducting the Richardson hearing, makes the determination whether it's inadvertent or willful, trivial or substantial, and whether it resulted in prejudice or harm. The discovery violation is not following Rule 3.220. add subsection A, subsection 1, subsection C, any written or recorded statements and the substance of any oral statements made by the defendant.
Okay.
Include-
So let's go back to what I was saying. So the only thing the state could have done to comply with this rule, seeing as how they didn't know about the statements apparently till Monday, was at that time hand you, I guess, some notes about what she told them that you already have, right?
We would have been sufficient,
Well, answer the question, please.
They could have told me and that would have satisfied the rule.
Well, I'm not asking that. I'm just saying that that is the chief complaint pursuant to the rule, that they did not give you those oral statements as a synopsis. Because if they had done that, then there would be no need to have this hearing.
I would agree.
Okay, so I doubt you, although interesting, this stuff goes both ways. This could be argued either way.
But that's not the issue.
I understand, well, it kind of is with prejudice, but anyway. So if they had provided you this oral statement, we wouldn't be here, but provided you with an oral statement you already have.
If they had provided us with an oral statement, absolutely, we would have given that oral statement to our experts. They would have been testifying about it the last 3 days.
Okay, so find me the case that says that, please.
The 3.220 says that they have to give it to us, which, what do you
I
guys?
understand, but I have to determine what the prejudice is. I don't think it was intentional.
So you want case law about the prejudicial effect?
Mhm.
Okay,
It says they can't use the statement.
okay.
Mhm.
Are we breaking for the day or what?
I was hoping we could determine what this issue, but we can't.
Well, I would need to do some research on the prejudice. I mean, all of our experts didn't rely on it and we've rested, so I will need to do some more research on the prejudicial effect of that.
You want to, we have a break for just
I
a
guess
minute or
one
two?
could argue that obviously, I guess the defense would decide not to give those statements to their experts, perhaps. Although I still think some of them support your defense and some of them don't, but you would be hardly surprised that the state called her.
When we last spoke to her, she had not talked to the state and we didn't have any, so I don't know why we would be surprised that they would call her. She told us she hadn't talked to the state, so we were of the belief that they would not call her. Certainly, if that changed, we expected that they would follow the rules and tell us.
Well, Mr. Ellis, did you tell him 2 days ago?
Yesterday.
Yes, sir.
Yes.
That they were calling her, not the content of her statements, correct?
Correct.
Correct.
Well, if they say, so I guess you were just waiting for it to happen and then say there's a discovery violation because I don't have an oral statement from her from the state, right?
We were under the assumption that they were gonna call her to essentially get out what Genevieve Torres has already called, since we weren't provided anything else.
And I'm sure if you knew, Mr. Ellis,
Observations of him.
if this was gonna happen, you would have summarized it on a sheet of paper and handed it to her.
Yes, Judge, I thought they were fully aware of all this, as she testified to it, they knew it before we did.
I know, but when you look at the rule, the letter of the rule, it says, that doesn't say whether they were aware of it, they weren't aware of it, who's gonna use it, but that under this situation, you should have given them the substance of the oral statements that they already had.
I guess you can make that technical decision, and
I'm not saying making that decision, I'm just asking.
Judge, could I have a couple minutes to talk to Mr. Ellis privately?
Yeah. You can go on the floor, you don't have to be here with us, you can if you want.
I'm here, it's all right.
You'd rather be sitting here than out in the foyer?
If you don't mind.
I don't care.
Okay. I'm already in this.
Continuing legal education.
We sent the jury home. Lucky we sent the jury home.
Should we approach that?
We can, I don't think we have to do this at the bench, do we? There's no reason to do this at the bench, just go ahead.
What's the site for that?
Your Honor, Scipio is at, and it's SCIPIO, Fee State 928, Southern 2nd, 1138, Florida Supreme Court, 2006. And I'm bringing this, may I continue?
What?
May I continue? I'm bringing this case up for the proposition about the prejudice when the court
Okay,
acquired.
yeah. Okay, just like Ibera, the statement was not disclosed pursuant to 3.220B1C, but in that case, the court didn't have a Richardson hearing, so they never got that far. It was reversed and remanded for a new trial because they found there was prejudice for sure, even though there was no Richardson hearing. Or so we're past that, we're out of here. It's an oral statement by the defendant to the police where the content of the statement had not been provided to defense counsel. You know what's interesting is this says, obviously, the oral statement the defendant made to the police was never provided to the defense counsel. Well, and they cite that discovery rule, but in this case, it has been provided to you.
Well, if you think about it, in that case, the defendant's statement's always provided because we have our client. But that's not what the rule requires.
No. In this case, it was the detective that he made the statement to, and they used it in rebuttal when he testified in the defense.
Right.
It had never been provided with the statement. So.
Right, but that's what I'm saying, is if the defendant made that statement, then the attorney, his client knows, right? So they're under the, that's what the court's saying, that if we're just gonna, if we're on notice, if our client tells us something, that they no longer have to tell us what they're alleged.
Reversed.
I know. that's what I'm saying. So even if we know about a statement, my client can come to me and say, I told this officer so-and-so, so-and-so, so-and-so. If the state never follows the discovery rules and puts me on notice that that's going to come in, I'm going to assume that it's not going to come in. I'm not just going to say, oh, well, my client told me that, so I'm assuming that that discovery rule is now met.
How are you prejudiced if in your rebuttal, I'm sure you will have numerous things to cover. I'm anticipating the rebuttal could almost be as long as the initial presentation, which it is what it is. But why can you not cure it by, you will have seen what their witnesses are going to say about it, you will have cross-examined them about it, and do it that way? How are you really prejudiced?
Brown v. State, 165 Southern 3rd, 726, 4th DCA. I haven't pulled up the case yet. Providing discovery to a defendant in one case does not relieve the state of its duty to give proper notice of its intent to use the same evidence in the defendant's other case. So that's a pretty close situation where they're saying we have this statement's defendant, but they don't discover it in another case, and so you're not put on notice. We weren't put on notice. We're prejudiced now because we've called 3 experts who have given lengthy testimony. They've been cross-examined. They weren't asked about this. Every opinion they offer, there's no way.
If they were asked about it, you would have been up here in 10 seconds saying you weren't provided with the use of these statements.
I agree. So it sounds like the state purposefully, they obviously knew we hadn't given them to our experts, or they would ask about it, right? They're either thinking that we didn't give them to our experts and operating under that guise, or they would have asked our experts about it. I'd ask the court to inquire if Dr. Burston and Dr. Lazaro have been provided these statements.
No, that's not the issue.
Well, it's an issue if they're providing it to their experts, but not the defense for us to provide to our experts.
I don't think that's an issue I have to address, is what they did with it. I think we all agree that Mr. Ellis and Mr. Boland didn't follow the letter of the Rules of Criminal Procedure 3.220B1C. I am not finding that it was an intentional violation. Knowing who their opposing counsel were, if they were aware of the rule, they would have provided it to you. There'd be no reason not to, because they would know they would end up in this situation. I didn't know the rule. Of course, I don't have to look at the rules like you all do, but I don't think it was intentional. I think this evidence is material for sure. I mean, it can be argued both ways. I mean, the 111 times 2 phone call, he's related to the Pope, he's going to the church. There were 2 of those. He didn't believe Phoebe was his daughter, and that his father had an affair with his girlfriend. I think that could be argued that's rather delusional. He doesn't know what to do anymore. I can't live without her. and the rest of it, not so good. Explain to me how things would have been different if the state had complied with the rule and you had knew they were going to use the statements that this witness has just testified to.
At this point, we don't know. What if we were to go to our experts right now and say, does this change your opinion? And they tell us yes. What do we do then? We haven't discussed it with them. So we couldn't even tell you how we would have proceeded differently. I guarantee if it was going to be evidence in the case, though, we would have given it to our experts. And so,
well, let me ask you this. Why would you have thought the state wasn't going to use that?
because the rule very obviously states that if they have the statement, they have to turn it over. When we spoke with Ms. Malcolm, she had indicated she had not told the state about him. So there's nothing that would suggest to us that they are coming in. And there's, oh, I'm sorry. There's a, in Scipio it says, it's going on, this is the case where there was a change in testimony from the deposition to the testimony at trial, and the state did not inform defense that there was a change in that testimony.
That's a Brady violation.
It's discovery violation also. And so they're saying that
this is an inadvertent mistake of what could be argued monumental significance to the defense. Would you agree with me on that? I mean, they didn't, who knows what their experts are going to say after they find out that these statements are coming in?
Well, one of their experts was present for the phone call.
She said there was an expert on the line. I don't know how, why don't you ask her some questions about that?
I did. Do you know who the expert was?
I don't remember the name, but I do remember them saying that there was a doctor on the line. I don't recall the names.
So they had the opportunity to address it with their experts.
Yeah, but if they don't know you're going to use it because you haven't provided them a summary, why bother addressing it? I mean, I agree in a way you know, I could say you're being ambushed, but so what? I mean, that's not a defense to not following the rules. So what
But Judge, if you feel that we did do a technical discovery violation, you look at prejudice, and they have the opportunity to serve a rebuttal.
Yeah, but it's not the same. I mean, I think Ms. Manuel's right. What happens if, you know, any one of those experts say, I don't think he's on GRI anymore?
And just regarding the procedural versus substantive prejudice, looking at the Scipio case, they go on to say an analysis of procedural prejudice does not ask how the undisclosed piece of evidence affected the case as it was actually presented to the jury. Rather, it considers how the defense might have responded had it known about the undisclosed piece of evidence, and contemplates the possibility that the defense could have acted to counter the harmful effects of the discovery violation. By contrast, an analysis of substantive prejudice would ask whether it was possible that the error affected the jury's verdict. While this standard itself is a high one for the state to overcome, it is of an entirely different quality than a procedural prejudice analysis. We now clarify,
I was interrupting you, go ahead.
Okay. We now clarify that Shope's harmless error standard does not focus on whether the discovery violation would have made a difference in the verdict. Such an analysis would make the standard for procedural prejudice identical to substantive prejudice. Instead, we reaffirm our statements in Shope that the inquiry is whether there is a reasonable possibility that the discovery violation materially hindered the defendant's trial preparation or strategy.
Judge, if I may, all those cases do with statements they didn't know. The defense didn't know that. I think that's cases where a witness materially changed their testimony. Again, it's things they didn't know.
Yeah, but that's, their position is, it has nothing to do with the fact they didn't know it. Their position is they weren't noticed pursuant to the discovery rules that you were going to use it. That's what their position is. Everybody knows everybody knew it. And it's pretty, I mean, one could argue that, I believe, I mean, I'm not a psychiatrist or a psychologist, that the 2 phone calls at 111 are almost beneficial to the defense, where he says he's the Pope twice. The stuff about his father had an affair with his girlfriend, that sounds pretty crazy to me, for lack of a better word. The 2:30 phone call, he does not know what to do anymore. I don't know how I can live without her. I don't think we ever heard, if I can't have her, nobody can. Did we ever hear that?
No, we did not.
I've read that somewhere, but I don't think I heard it at the trial. I don't know how I can live without her. Did we hear that?
No.
Okay. So that's all new. That's extremely prejudicial. I don't know how else to describe it. And then the 5th phone call, can you call DCF? Well, the domestic violence injunction's in evidence, and that would seem to suggest that I think the defenses aren't going to argue that he was having delusions about what was going on in Michelle's house. So can you call DCF might be a logical next step. Can I get a DNA test if he actually believed that his father was the father of the child and not him? That would kind of be a logical step. I don't know what to do. I don't think that phone call is so horrible. Everyone is, didn't he make the statement to somebody, everything will be okay tomorrow? Didn't he say that to Torres?
Yeah,
Everything,
don't worry about filing the paperwork, nothing's gonna matter tomorrow.
okay, so that's the same thing we've already heard, and I'm sure the experts, your experts, are gonna talk about it. So really, when you really look at it, the terrible part of this for the defense is I don't know how I can live without her. If I can't have her, nobody can. Agree? The rest of it could go either way, or we've already heard it. But that's bad for their case. I don't know what to do.
Can we take some time to research it tonight? Judge?
Oh, yeah. I mean, I think it's a problem. Do you agree with the analysis on the rest of it? That it's really not that problematic?
I think it's problematic. Let's say somebody is up on sur rebuttal. One of the jurors has a question about it on sur rebuttal. I mean, it looks like we're somehow hiding it.
Well, I'm thinking of it, and I don't know, I'm going to listen tomorrow morning, but I'm thinking the resolution to it is that phone call, the 4th phone call, doesn't come in. And all the rest of them do, because you're really not prejudiced. Some of them, I think, support your defense, and the one that doesn't is everything will be okay tomorrow, but we've already heard about that at the same law office. In fact, was Ms. Torres there when you, oh, that's a phone, never mind, but we've already heard about it.
I don't disagree with the
So that's a possible solution, from my perspective.
No, I don't disagree with the court.
You're saying
So-
keep out the statement
The 4th phone call.
the
That's-
statement that we just learned about.
Yeah, because I don't think anybody can argue that it's not highly prejudicial. So that's a given. It's highly prejudicial. The discovery rules were violated, not intentionally. It's, I don't want to call it an obscure discovery rule, but I don't think either one of you, if you'd known it, you would have done it. So it's inadvertent, but it's really prejudicial. I mean, they can't fix it. Do you have anything else you want to say? I mean, I'll decide tomorrow morning, but,
Not till tomorrow morning.
okay.
We'll
Mr. Ellis?
We'll talk tomorrow, Judge.
Okay. Anything else we need to do today?
think so. Did you, we're say 9:30 tomorrow?
Did I tell them 9:30?
Yes.
Okay, yeah, 9:30. For you too,
For me too.
right? She's coming back at 9:30? Yes. State, you want her back at 9:30, right?
Yes, Your Honor.
Okay. Yes, ma'am. Thank you for your patience.
No problem.